Okay, I'm reading Chapter 2 of Criminal Procedure. I'm up to Section 3 of the chapter, Freestanding Due Process. And the Supreme Court in the post-selective incorporation era has continued to apply due process as a guarantee that has independent content. Standing apart from the selectively incorporated guarantees, at times the court has suggested that this freestanding element in process should be approached with caution. Thus, Dowling v. United States in 1990 noted that beyond the specific guarantees enumerated in the Bill of Rights, the Due Process Clause has limited operation and will be construed very narrowly. This position rests on the grounds that since the Bill of Rights speaks in explicit terms to many aspects of criminal procedure, the expansion of constitutional regulation under the open-ended rubric of the Due Process Clause invites undue inference with both considered legislative judgments and the careful balance that the Constitution strikes between liberty and order. Medina, I'm assuming, is a quote from Medina versus California, 505 U.S. 437 in 1992. Notwithstanding such statements, which are pretty long, this position rests on the ground that since the Bill of Rights speaks in explicit terms to many aspects of criminal procedure, the expansion of constitutional regulation under the open-ended rubric of the Due Process Clause invites undue interference with both considered legislative judgments and the careful balance that the Constitution strikes between liberty and order. Notwithstanding such statements, freestanding due process has emerged as one, the dominant source of constitutional regulation of the pretrial and post-trial stages of the process, most notable as to guilty pleas and sentencing, and two, a major source of constitutional regulation of the trial, and three, a lesser but still significant source of regulation of police practices. These rulings relying on the independent content of due process are scattered throughout this volume. District Attorney's Office v. Osborne, set forth below, reflects the differing perspectives that have often divided the court in its determination of the independent content of due process. District Attorney's Office v. Osborne. This was heard in 2009. Looks like it could be the Supreme Court. And Chief Justice Roberts delivered the opinion of the court. So in 1993, respondent Osborne was convicted of kidnapping and sexual assault. He claimed that at trial he had asked his attorney to seek DNA testing and biological evidence on a condom found at the scene of the crime, but she refused. His lawyer testified that she refused for various reasons, including her belief her client was guilty. This led her to conclude that further testing would do more harm than good. There was considerable evidence of Osborne's guilt. Moreover, he confessed to the parole board, which released him after 14 years. Osborne subsequently claimed he lied to the parole board because he hoped his lie would lead to a quicker release. Osborne was recently rearrested for another crime, and the state has petitioned to revoke his parole. Osborne asked the Alaska Court of Appeals to provide the DNA testing that his trial lawyer had failed to request, but that court denied relief, relying heavily on the fact that Osborne had confessed to some of his crimes in the application for parole. Osborne also brought a federal action under Section 1983, claiming that the Due Process Clause entitled him to a form of DNA testing more discriminating than the methods available at the time of his trial. A federal district court concluded that Osborne had a right, but a very limited one, to the testing sought. The U.S. Court of Appeals of the Ninth Circuit affirmed, concluding that the prosecutorial duty to disclose exculpatory evidence extends the government's duty or the defendant's right of access to post-conviction proceedings. Although it acknowledged that Osborne's prior admissions of guilt were certainly relevant, the Ninth Circuit concluded they did not necessarily trump the right to obtain post-conviction relief, considering the emerging reality of wrongful convictions based on false confessions. DNA testing has an unparalleled ability to exonerate the wrongly convicted and to identify the guilty. It has the potential to significantly improve both the criminal justice system and police investigative practices. The federal government and the states have recognized this and have developed special approaches to ensure that this evidentiary tool can be effectively incorporated into established criminal procedure, usually but not always through legislation. Against this prompt and considered response, the respondent, William Osborne, proposes a different approach. His approach would take the development in this area out of the hands of legislators and state courts, shaping policy in a focused manner, and turn it over to the federal courts applying the broad parameters of the Due Process Clause. There is no reason to constitutionalize the issue in this way. DNA testing alone does not always resolve a case. Where there is enough other incriminating evidence and explanation for the DNA result, science alone cannot prove a prisoner innocent. The availability of technologies not available at trial cannot mean that every criminal conviction or even every criminal conviction involving biological evidence is suddenly in doubt. The dilemma is how to harness DNA's power to prove innocence without necessarily overthrowing the established system of criminal justice. That task belongs primarily to the legislator. 46 states have already enacted statutes dealing specifically with access to DNA evidence. The federal government has also passed the Innocence Protection Act of 2004, which allows federal prisoners to move for court-ordered DNA testing under certain specified conditions. That act also grants money to states that enact comparable statutes. These laws recognize the value of DNA evidence, but also the need for certain conditions on access to the state's evidence. A requirement of demonstrating materiality is common, but it is not the only one. The federal statute, for example, requires a sworn statement that the applicant is innocent. States also impose a range of diligence requirements. Several require the requested testing to have been technologically impossible at trial. Others deny testing to those who decline testing at trial for tactical reasons. Alaska is one of a handful of states yet to enact legislation specifically addressing the issue of evidence requested for DNA testing, but that does not mean that such evidence is unavailable for those seeking to prove their innocence. Instead, Alaska courts are addressing how to apply existing laws for discovery and post-conviction relief to this novel technology. First, access to evidence is available under Alaska law for those who seek to subject it to newly available DNA testing that will prove them to be actually innocent. Under the state's general post-conviction relief statute, a prisoner may challenge his conviction when there exists evidence of material facts not previously presented and heard by the court. That requires vacation of the conviction or sentence in the interest of justice. Such a claim is exempt from otherwise applicable time limits if newly discoverable evidence, pursued with due diligence, establishes by clear and convincing evidence that the applicant is innocent. Both parties agree that under these provisions, the defendant is entitled to post-conviction relief if that's a long case. Post-conviction relief if the defendant presents newly discovered evidence that establishes by clear and convincing evidence that the defendant is innocent. If such a claim is brought, state law permits general discovery. Alaska courts have explained that these procedures are available to request DNA evidence for newly available testing to establish actual innocence. In addition to the statutory procedure, the Alaska Court of Appeals has invoked a widely accepted three-part test to govern additional rights to DNA access under the state constitution. Drawing on the experience of DNA evidence of state Supreme Courts around the country, the Court of Appeals explains that it was reluctant to hold Alaska law offers no remedy. To hold that Alaska law offers no remedy to defendants who could prove their factual innocence. It was prepared to hold, however, that a defendant who seeks post-conviction DNA testing must show, 1, that the conviction rested primarily on eyewitness identification evidence, 2, that there was a demonstrable doubt concerning the defendant's identification as a perpetrator, and 3, that scientific testing would likely be conclusive on the issue. Thus, the Alaska courts have suggested that even those who do not get discovery under the state's criminal rules have available to them to safety valve under the state constitution. This is the background against which the Federal Court of Appeals ordered the state to turn over the DNA evidence in its possession, and it is our starting point in analyzing Osborne's constitutional claims. The Due Process Clause imposes procedural limits on the state's power to take away protected entitlements. Osborne argues that access to the state's evidence is a process needed to vindicate his right to prove himself innocent and get out of jail. Process is not an end in itself, so a necessary premise of this argument is that he has an entitlement, what our precedents call a liberty interest, to prove his innocence even after a fair trial has proved otherwise. We must first examine this asserted liberty interest to determine what process, if any, is due. All right, so I'm guessing above is the facts and maybe a little bit about legislation development. In Alaska. Anyhow, Osborne does have a liberty interest in demonstrating. Actually, some of this was his issue right here. We need to see a liberty interest. That's definitely one issue. And they believe he has one. Osborne does have a liberty interest in demonstrating his innocence with new evidence under state law. As explained, Alaska law provides that those who use newly discovered evidence to establish by clear and convincing evidence that they were innocent may obtain vacation of their conviction or sentence in the interest of justice. This state-created right can, in some circumstances, beget yet other rights to procedures essential to the realization of the parent right. So, I guess this is the rule in Alaska. The Court of Appeals went too far, however, in concluding that the Due Process Clause requires that certain familiar post-conviction trial rights be extended to protect Osborne's post-conviction liberty interest. A criminal defendant, and so this sounds like a holding. A criminal defendant proved guilty after a fair trial does not have the same liberty interest as a free man. At trial, the defendant is presumed innocent and may demand that the government prove its case beyond reasonable doubt. But once a defendant has been afforded a fair trial and convicted of an offense for which he is charged, the presumption of innocence disappears. Herrera v. Collins. The state accordingly has more flexibility on deciding what procedures are needed in the context of post-conviction relief. Osborne's right to due process is not parallel to a trial right, but rather must be analyzed in light of the fact that he has already been found guilty at a fair trial and has only a limited interest in post-conviction relief. The question is whether consideration of Osborne's claim within the framework of the state's procedures for post-conviction relief offends some principle of justice so rooted in the traditions of and conscience of our people as to be ranked as fundamental, or transgresses any recognized principle of fundamental fairness in operation, from Medina versus California. Federal courts may upset a state's post-conviction relief procedures only if they are fundamentally inadequate to vindicate the substantive rights provided. We see nothing inadequate about the procedures Alaska has provided to vindicate its state right to post-conviction relief in general, and nothing inadequate about how those procedures apply to those who seek access to DNA evidence. Alaska provides a substantive right to be released on a sufficiently compelling showing of new evidence that establishes innocence. It exempts such claims from otherwise applicable time limits. The state provides for discovery in post-conviction proceedings and has, through judicial decision, specified that this discovery procedure is available to those seeking access to DNA evidence. These procedures are not without limits. The evidence must indeed be newly available to qualify under Alaska statute, must have been diligently pursued, and must also be sufficiently material. These procedures are similar to those provided for DNA evidence by federal law and the law of other states. This attempt to sidestep state process through a new federal lawsuit puts Osborne in a very awkward position. If he simply seeks the DNA through the state's discovery procedures, he might well get it. If he does not, it may be for a perfectly adequate reason, just as the federal statute and all state statutes impose conditions and limits on access to DNA evidence. It is difficult to criticize the state's procedures when Osborne has not invoked them. These procedures are adequate on their face, and without trying them, Osborne can hardly complain that they do not work in practice. As a fallback, Osborne also obliquely relies on the asserted factual constitutional right to be released upon proof of actual innocence. Whether such a federal right exists is an open question. We have struggled with it over the years, in some cases assuming arguendo that it exists, while also noting the difficult questions such a right would pose and the high standards any claimant would have to meet. House versus Bell and Herrera versus Collins. So I think this is another sub-issue, but I think it might be the first sub-issue. Wasn't really stated as a question, but like, can he get out of jail if he does get DNA showing that it wasn't his? And that hasn't been answered. In this case, too, we can assume without deciding that such a claim exists, because even so, there is no due process problem. Osborne does not dispute that a federal actual innocence claim, as opposed to a DNA access claim, would be brought in habeas. If such a habeas claim is viable, federal procedural rules permit discovery for good cause. Just as with state law, Osborne cannot show that available discovery is facially inadequate and cannot show that it would be arbitrarily denied to him. The Court of Appeals below relied only on procedural due process, but Osborne seeks to defend the judgment on the basis of substantive due process as well. He asks that we recognize a freestanding right to DNA evidence untethered from the liberty interest he hopes to vindicate with it. We reject the invitation and conclude in the circumstances of this case that there is no such substantive due process right. As a general matter, the court has always been reluctant to expand the concept of substantive due process because guideposts for responsible decision-making in this uncharted area are scarce and ended. Osborne seeks access to state evidence so that he can apply new DNA testing technology that might prove him innocent. There is no long history of such a right, and the mere novelty of such a claim is reason enough to doubt that substantive due process sustains it. Okay. And there are further reasons to doubt it. The elected governments of the state are actively confronting the challenges DNA technology poses in our criminal justice systems and our traditional notions of finality, as well as the opportunities it affords. To suddenly constitutionalize this area would short-circuit what looks to be a prompt and considered legislative response. By extending constitutional protection to an asserted right or liberty interest, we, to a great extent, place the matter outside the arena of public debate and legislative action. We must therefore exercise the utmost care whenever we are asked to break new ground in this field. We are reluctant to enlist the federal judiciary in creating a new constitutional code of rules for handling DNA. Establishing a freestanding right to access DNA evidence for testing would force us to act as policymakers, and our substantive due process rulemaking authority would not only have to cover the right of access, but a myriad of other issues. We would soon have to decide whether, if there is a constitutional obligation to preserve forensic evidence that might later be tested. Arizona versus Youngblood, page 733. If so, for how long? Would it be different for different types of evidence? Would the state also have some obligation to gather such evidence in the first place? How much and when? No doubt there would be a miscellany of other minor directives. So it's like not justiciable. DNA evidence will undoubtedly lead to changes in the criminal justice system. It has done so already. The question is whether further change will primarily be made by legislative revision and judicial interpretation of the existing system, or whether the federal judiciary must leap ahead, revising or even discarding the system, creating a new constitutional right and taking over responsibility for refining it. Federal courts should not presume the state criminal procedure will be inadequate to deal with technological change. And that is going to be the end and the beginning of concurring opinions at the least, which I'm going to hold off on in this recording.